Good afternoon, everyone. Good afternoon, Jyoti. Prashant. Good afternoon. So, should we start our discussion?
Yes, sir.
Okay. So, see, today we are scheduled to discuss section 43, capital A. It's talking about, the compensation for failure to protect the data. And compensation indicate that it is the civil remedy it talking about. And this civil remedy is when the body or the company to whom you have your data with that company has failed to protect your data. So for that particular negligence, this particular wrong is talking about. And here the word data has been written to protect the data, but this data does not mean your personal data. It means your sensitive personal data. Okay, for data protection still we are lacking. India is lacking for having any special legislation. The bill was before the parliament, 2019 bill with respect to personal data protection bill. In the European country they have GDPR, some protection of the data there, but we don't still have. Maybe in the future we will have a robust framework to protect our personal data. But definitely when the act was enacted in 2000, information technology, the legislature have missed out this type of the provision, and later on 2009 they have made the amendment and made it that if there is the failure on the part of the company or any entity to which or that is dealing with our data, earlier if you remember we heard that data has been was present in the public domain from the DAI, this Aadhaar company. So this type of the things, see, in the normal life we provide many sensitive informations to other persons, and sometimes those sensitive information are with our companies. When you file OTP, when you have password, etc., so these companies they have to protect it because the cyberspace is very crime prone domain. And then if the sufficient reasonable practice has not been prescribed, then it is always possibility that those sensitive information will fall in the wrongdoer and then they will cause the damage. Okay, so it was through the way of amendment 2009 this particular provision was inserted. I have shared the screen and you will find that section 43 capital A, compensation for failure of data, this marginal note says, when a body corporate possessing, dealing or handling any sensitive personal data or information in a computer resource which it own, control or operate, is negligent in implementing and maintaining the reasonable security practices and the procedure, and thereby cause wrongful loss or wrongful gain to any person, such body corporate shall be liable to pay damages by way of compensation. And here you can divide this section into 4 parts. Okay, the first one is that there must be a body corporate, and this body corporate either possess or it is dealing or it is handling. That means either the data, your personal sensitive data is with it, this company, or it is handling it, or it is processing it. But the question is that what is body corporate? And the body corporate, if you understand and you read section 9 of the Companies Act, that the date that is mentioned in the certificate of incorporation, all the subscriber or the member or with the time and to time shareholder will become a body corporate. So body corporate is a separate personality created by the law. Okay, and in the jurisprudence you will read that about more about the body corporate, that certain person come together and law recognize collectively these person as a separate person is the body corporate. The test to find out the body corporate is that if that particular entity in his own name may issue or be issued, that it is body corporate. The body corporate is the process that create a legal person, the juristic person, and this legal person or juristic person is always created by the law. Like Article 300A of 300 or 300A of the Indian Constitution, that's saying that the central government of the Union of India can be filed the case in the name of Union of India, and the state government in the name of their respective state, and so that provide the status of the juristic person or a separate personality to our what you say, it's Article 300. Okay, so that is giving the power or giving the personality to the Union of India and to the different state. Whenever there is a question, you have to find out, the important test is you have to find that whether this particular institution will in its own name can file the case or no. If yes, that yes, it's separate person. If no, then it is not separate person. The next thing is that the separate personality or the body corporate, either the status is given by the law, कोई ना कोई statute होगा जिसका provision उसको ये status दे रहा हो, or it will be recognized by the court. Like the idol, जो टेम्पल में आइडल जो वो बैठा होता है हमारा मूर्ति, that is separate person in the juristic person in the eyes of law. Mosque is not a juristic person. 1 year back, Uttarakhand High Court held that the Ganga is a juristic person when its case is before the Supreme Court. So that type of the thing is there. And company is a separate person, a body corporate. Body corporate became after the incorporation. So incorporation is the process by which body corporate is formed, and the partnership is not a body corporate. But here, if the word has not been defined, then we have to take the loose meaning of the body corporate or that separate personality. But the question is that maybe this type of dealing of sensitive data is not by a company. It may be by the partnership or some other type of thing. Limited liability partnership is also body corporate. When you read Limited Liability Partnership Act 2008, you will find it. And so here the body corporate has been defined under the explanation that is attached with this section 43. It's visible on the screen, and it says try to include all other entities or association of the person that are not incorporated, that are not duly incorporated, that may not be strictly body corporate, but just to widen the scope of section 43. If this had not been done, then only the body corporate or the association of person who strictly be known as or considered as the body corporate would be liable. So just to increase the scope, the legislature has put this explanation that body corporate means any company. Okay, that would be including firm, sole proprietorship or other association of individual engaged in commercial or the professional activity. So these other association of the person are like the firm or other type of the things would not be strictly body corporate, but the parliament thought that maybe they are doing the activity and they would be negligent, so why to make the difference, and so they have just defined this particular word to include the scope of the provision. So the first ingredients of the section 43 is body corporate. It is possessing, that means the data is in the possession of this particular company, like Aadhaar, this authority UDAI, and this authority have all our data, our fingerprints, our ERIC, what you say that mark, our address, etc. So these information these companies have. Similarly, when you go to the hospital, you make some other information, like maybe your sexual orientation with some other information that may be termed as the prejudicial to you. Okay, so that thing. And so the many authorities we make this type of the information to the insurance company, etc. Then either it is dealing with it, maybe it's not possessing, but the process is, it's just to widen the scope, these three words has put here, that either possessing or handling or dealing. Okay, so this is the first ingredient. Now the second ingredient is that any sensitive personal data or the information. That means this section is not applicable for all type of the data. No, this section is applicable with respect to your personal data, and then with respect to sensitive personal data. So these two adjectives are put with the data just to specify. And then the question is that, okay, sensitive personal data, but what is sensitive personal data? Whether our name is sensitive personal data or not, whether our sexual orientation is sexual personal data, sensitive personal data or not, whether our password is sensitive personal data or not, whether I have this much of height or weight is sensitive personal data or not, family status is sensitive personal data or not, and in which institution you are studying, or like with the film actor to which movie he is doing, etc., whether that is sensitive personal data or not. And so it's very important to determine or define the sensitive personal data. And for that, again, there is a confusion to whom we will call sensitive personal data or not. Maybe you all agree that password is a sensitive personal data, OTP is the sensitive personal data, your card number is the sensitive personal data. Okay, so these public gateway or any this type of the company that are dealing with these sensitive data, they are liable if there is negligence on their part. Okay, so this section is provision is a great rescue for us. Okay, sensitive personal data, if you will find here explanation 3, it says that sensitive personal data or information means such personal information as may be prescribed by the government in consultation with such professional body or association as it deem fit. So it's not defining, explanation is not defining, rather it inferring that the sensitive personal data means such data to which the central government will make the rules that these are the sensitive personal data. And the rule making power is given under the Information Technology Act, and the central government has framed the rule after consultation with different bodies, professional bodies, and then they framed the rule. These rules known as Information Technology Act, reasonable security practices, and just give me 1 second. Yes, reasonable security practices and procedure and sensitive personal data information. I just shared the screen, you can watch here, and there these rules, how we will read numberings, like there is a different terminology when you read the document like the constitution or the treaty. There that document is divided into different portions like 1 2 3 with numbering, and those different portion is known as articles. Article 1 2 3 4 5. If you have the act or the code, both are the statute passed by the either parliament or the state assembly, and they are separated with different numerals 1 2 3. So you call those numerals as sections. When there is the rules like this rule, then these numerals will be known as rules. Rule 1, rule 2, rule 3. जो 3 number है तो rules 3. Okay. If it is the regulation, then regulation 1, regulation 2, regulation 3, etc. If it is ordinance, if it is the statute, like the Delhi University with the Delhi University Act 1922, it has Delhi University was started in 1922. This is the centenary year. 100 साल हो गए यूनिवर्सिटी को. लॉ फैकल्टी 1924 में इस्टेब्लिश हुई. लॉ फैकल्टी को ऑफ दिल्ली यूनिवर्सिटी 1924 में 100 ईयर्स की हो जाएगी. सो दिस what I was saying, that in the statute जो numbering होती है, statute 1, statute 2, statute 3 we will see. So here this rule 3 is talking about the sensitive personal data and information, and this rule 3 is as per the explanation 3 of the section 43, that talking about that the sensitive personal data or information means as defined by the central government through the rules. Can any of you read these clauses here? Yes, to the sensitive personal data or information. Sanjay?
Yes, sir.
Yeah, read it.
So from
this rule 3, sensitive personal data or information.
sensitive personal data or information. Sensitive personal data or information of the person means such personal information which consists of information relating to one's password, to financial information such as bank account or credit card or debit card or other payment instruction details. Third, physical, psychological and mental health conditions. Fourth, sexual orientation, fifth, medical records and history. Fifth, biometric information. Seventh, any details relating to above clauses as provided to body corporate for providing service. And eighth, any of the information received under above clauses by body corporate or processing, stored or processed under lawful contract or otherwise, provided that any information that is freely available or accessible in public domain or furnished under the Right to Information Act 2005 or any other law for the time being in court shall not be regarded as sensitive personal data or information for the purposes of.
Yeah, thank you, Sanjay. So here 7 clauses are there, and it's saying that password it may be your bank account password, it may be your other account password. So that is the sensitive personal data. Then the second, it's saying the financial information such as bank account, credit card, debit card and other payment instrument details. So these information means like your bank statement, how much spending you have done in the last month, what was your last transactions, all. It's not saying only about your account number, any information with respect to that may be how much spending you have, how much loan you have, all these information would be sensitive personal information. Then the third one is about the physical, psychological or mental health condition. The fourth one is the sexual orientation, like whether a person is gay, lesbian, etc. And here there is the proviso that come for the rescue. Suppose with respect to a particular person, A has put this information to his particular hospital or a particular insurance company about that doing the insurance, that he is a gay. Okay, and same information is available in the public domain also. Okay, so then he cannot say that this particular information has been came outside because it was already in the public domain, and so the proviso is great rescue for such information that may be under the under this rule 3 as a sensitive information like the mental health etc, but because it is already available under the public domain, so it is not covered there. That's why the proviso is here. Then the biometric information, the biometric means our fingerprints, our retinal code, maybe our ear mark. There are different types of the biometrics we science know, and all those would be applicable. Then the next one is about any detail relating to the above clauses. So with respect to these clauses, if you have provided your information to body corporate for providing services, or any information received under these clauses by body corporated for possessing, storing or processing any lawful contract or otherwise. And so Aadhaar, this UDI, that having the record of our Aadhaar is also that authority that having this detail of our biometrics marks, so that would be covered under it. So this defines the sensitive personal data. So the first is the body corporate possessing, handling or dealing. The second is the sensitive personal data or the information. Now the third one is that there must be negligence. Negligence on whose part? Negligence on part of this body corporate. Negligence on part of the body corporate who is dealing, possessing or handling your personal data. So on that body part there would be negligence. And to clarify it, that how to prove the negligence, whether they are negligent or not, when they are considered to be the negligence, there must be some standard framework or some standard procedure that this much of the security they have to provide it, and if they have not provided, in that case only we can say that they were negligent. And so the third is section 43, talking about the reasonable security practices. Subsection this explanation 2 of the section 43 define the reasonable security practices and the procedure. It's saying that the reasonable security practices and the procedure means security practice and the procedure designed to protect such information from unauthorized access, damage, use, modification, disclosure or impairment as may be specified in any agreement between the party or as may be specified in any law for time being in force, and in absence of such agreement or any law, such reasonable security practices procedure as may be prescribed by the central government in consultation with the such professional body. So it's saying either this security procedure and practice means designed to protect the information from the unauthorized access as may be specified in the agreement between the party. So suppose one has agreed with a particular body corporate that you will possess this type of the security procedure, and as per their agreement they have to apply that security procedure and they have not applied that one. Or if there is no agreement with respect to the security practices or procedure, then we have to see that through the law rule making power, the central government has framed the rules with respect to the security practices and procedure. The same rules we have to read it here. Then in that case, if that security procedure has not been provided, then it would be called as the negligence on the part of the body corporate. Rule number 8 of the information technology, reasonable security practices and procedure and protection of sensitive personal data rules 2011. Rule number 8 talk about the reasonable security practices and procedures. Yes, Sanjay, please read it.
Yes, sir. Reasonable security practices and procedures. 1. A body corporate or a person on its behalf shall be considered to have complied with reasonable security practices and procedures if they have implemented such security practices and standards and have a comprehensive documented information security program and information security policies that contain managerial, technical, operational, and physical security control measures that are commensurate with the information assets being protected with the nature of business. In the event of an information security breach, the body corporate of a person on its behalf shall be required to demonstrate as and when called upon to do so by the agency mandated under the law that they have implemented security control measures as per their documented information security program and information security policies. To the international standards ISO IEC 27001 on information technology, security techniques, information security management system. Requirement is one such standard that is referred to in sub-rule 1. Third, any industry, association or an entity formed by such an association whose members are self-regulating by following other than ISO IEC codes of best practices for data protection as per sub-rule 1 shall get its code of best practices duly approved and notified by the central government.
Yeah, thank you, Sanjay. So, guys, you can read it in detail. And why we read this thing? Because to find out that it's whenever there would be the question when you go for the compensation, it's first duty to you to prove, but the duty is not like in the criminal proceeding, because in the criminal proceeding, the burden is to prove as the without any reasonable doubt, but here is the preponderance of the probability. But then also it is the duty when you want compensation, it's your duty to prove that there was the negligence. So that thing you have to provide, that this security procedure has to be applied in this case, but the company has not provided this thing. Okay, now the fourth element of the section 43, and the fourth element is, if you remember, is the wrongful loss or wrongful gain. Because in the section 43, where we read section 43 small a, small b, etc., there also, in Vinod Kaushik versus Madhvika Joshi, Delhi High Court has said, and in second case Amit Dilip Patwardhan, the adjudicating officer Mr. Rajesh Agrawal said that for the compensation, the damages the aggrieved person has to show. Okay, separately they have to show that these are the damages and the evidence has to be given for with this. Similarly, here this fourth portion is about the wrongful loss or the wrongful gain. One has to show, because without the loss or without the gain to some other person, the compensation would not be awarded. So the fourth element is the wrongful gain or the wrongful loss. Okay, these are the four elements. One is that there must be a body corporate that dealing, possessing or handling. Second is the sensitive personal data or information as per the rule 3 of the information technology, reasonable security practices and procedure and protection of sensitive personal data rules 2011. Then the third one is that there must be the negligence on part of that body corporate with respect to the handling, with respect to applying the reasonable security practices or the procedure as provided under the rule 8. And the fourth one is that there has to be the wrongful loss or wrongful gain to any person. Here you can read from section 43 that thereby causes wrongful loss or wrongful gain. Now the question is, what is wrongful loss or wrongful gain? Because this phrase has not been defined, like defined as the body corporate. So some inference we can take from the IPC. Inference I am saying, not I am saying that directly we can import it. So wrongful loss means the person who are or wrongful gain, both. The wrongful loss means the loss by any unlawful means of a property to which the person who suffered the losses, or you can say who is losing, was legally entitled. So if a person A is legally entitled to a particular property and someone snatched him, so that is the wrongful loss. So wrongful loss is actually the loss by unlawful means of the property to which the person losing it is legally entitled, and wrongful gain is the gain by unlawful means of the property to which the person gaining is not legally entitled. So this is the wrongful loss and wrongful gain. So any momentary gain the person will get, or any monetary loss you have suffered because password has been fallen in the hand of some other person, and this was because the body corporate was not actually provided that security procedure that has been required as per section 8 of the IT rules 2011. Then what the section says, that the body corporate shall be liable to pay damages by way of compensation to the person affected. And here the two things are very important. One is, such body corporate shall be liable to pay damages. That means it's talking about unliquidated damages that will be calculated with respect to how much damage, how much loss he has done. Sometimes exemplary damages can also be granted. And then compensation is talking about that again reaffirm that it is the civil remedy. Then to such person means that person will have the locus standi to go to stand before the court and ask for the, only that person against whom the damages is, or who suffered the losses, only that person. Okay, so this is the end of this section. Now there are 2-3 cases provided in your case material, and these cases are very, very important to understand the liability under section 43 capital A. The first case I am discussing here is Sri Sanjay Govind Dande versus ICICI Bank and Vodafone India. The case is very simple, as earlier also I have told that we have to see every case with respect to the 5 points. First is the facts of the case, because facts remain unchanged. Maybe it is decided by one forum, then in the appeal it would be the judgment will be reversed, then in the second appeal again the judgment would be reversed. The fact will remain same, and fact does not mean each and every fact. You have to remember, fact means those facts that will affect the judgment. Okay, the second is the case history, because most of the cases we read from the High Court or the Supreme Court, but definitely some cases here are from the adjudicating officer also, because it is just the inceptions, and cases will not going to Supreme Court directly. They will go first to adjudicating officer, then to the tribunal, and then to the High Court, etc. in this way, or maybe through SLP to the Supreme Court. Okay, so this is the case history. Third is the issue. What is the issue? Fact in issue. The those facts that are in the dispute is known as the fact in issue in the civil cases. And then the fourth one is fact in issue or issue of fact. Okay, the fourth one is the arguments from both the party, and fifth one is the decision, or that means the reasoned decision. So here are the facts are simple, that there is this Mr. Sanjay Govind Dande. The name of the case is written in A versus B. Always it would be written in A versus B, because we have the adversarial system, and so it's always between two party. except when it is under article 143, that is the opinion sought by the government. So then it will be written INRE, in re, like in re berubari, union and exchange of enclave case, etc. Okay, so that is known as the name of the parties. And in the name of the parties, the first party, when it would be A versus B, A would be in the criminal cases as the prosecution, B would be defense. Then they appeal, in the appeal when they go, if the judgment was in favor of the defense, so prosecution will go in the appeal. If the judgment was in favor of the prosecution, defense will go into the appeal, and so accordingly it will keep on changing. Okay, so from A versus B we can find out A is the person who went into this particular forum for getting the relief, and he has all burden. Second is then the citation. Okay, citation like AIR 1982 558. So these AIR, SCC, SCR are the journal. AIR All India Reporter, SCC Supreme Court cases. All these journal are the private journal except the SCR, that is the Supreme Court reports, and it is published by the registry of the Supreme Court. Okay, then the year number is written, so that is the journal, and in that particular year, that journal, that volume if also mentioned in that volume, and the page number you will find the case. Okay, here the she reads Sanjay Dhande versus ICICI Bank and Vodafone India adjudicating officer. So it was not from Supreme Court or High Court, it was from adjudicating officer under section 46 of the IT Act. Case are simple, that there is Mr. Sanjay Dhande. Mr. Sanjay Dhande, Sanjay, is it audible? Can you hear me?
Yes, sir. Yes,
Yeah.
sir.
So Mr. Sanjay Dhande has account in the ICICI Bank. That ICICI Bank is very good bank, and so he opened the account in ICICI Bank, and he subscribed for the mobile banking. अभी तो नहीं, अभी तो इंटरनेट बैंकिंग पे इम्फेसिस होता है, पहले मोबाइल बैंकिंग पे आप जाते थे बैंक में तो कहते थे सर मोबाइल बैंकिंग ले लो. So he subscribed mobile banking, that means ICICI issued him the mobile banking, that through the mobile he can do many transactions or many activities and no need to come to the bank. Okay, and the mobile number on which this service was issued, that SIM was from the Vodafone. वो SIM किसकी थी? Vodafone company की. Now what happened, that on a particular date 6th September 2013, Sanjay Dhande observed that his phone was not working properly. So what he did, that on the 7th, through the driver they contacted to the Vodafone center. So Vodafone representative checked the phone and found that sir phone तो आपका सही है, but सिम में कुछ गलती है, सिम आपकी चेंज करनी पड़ेगी. उन्होंने कहा ओके. And on the 8th and 9th there was holiday. On the 10th, Mr. Sanjay Dhande, what he did, he will collected all the paper etc, like for new SIM, the mobile, that PAN card etc, all those things that also required, and then the new SIM on the place of the old SIM has been issued with the same number. When this new SIM he start operating, he got the messages that from your account this much of the money is withdrawn, this much of the money is withdrawn, and total 19 lakh rupees were actually hyphened, okay, has been withdrawn from some unknown person. So these are the facts. Have you got these facts, Prashant? Facts समझ में आए?
Yes, sir.
Okay. Now question is that he filed the cyber in the cyber police station FIR also, and then someone has advised him that you have to go to the adjudicating officer, and so he filed the under section 46, he go before the adjudicating officer and filed the case that because of the wrong practices, during the investigation, there are some other facts also, that during the police investigation also it was found that the Vodafone SIM card, the Vodafone has issued between this time 6th and 10th another SIM card to some other person without properly verifying the document. Those documents were forged in the name of some other person who was the some other person. And so all those information, all those facility that ICICI Bank was providing, now this person Vodafone, through this Vodafone, the other person who got the SIM card, he can do, and he did those activity, and by which the money was transferred to some other account. Now the arguments of Sanjay Dande is that ICICI Bank and Vodafone both are liable for the section 43 capital A, because the liability of the Vodafone is that they have provided the SIM card, and SIM card is not the information but a battery of information. Okay, and so they not have provided a single information but the whole source by which many information can be given to the person in whose hand this SIM was there, and they issued the same SIM card without duly verifying the documents that the person who applying is the Sanjay Dande or not, and that was on some other fake document of some third person, not of the Sanjay Dande. And so this battery of information have provided or give the advantage to these persons, and so they are negligent in dealing, because the Vodafone is a body corporate, is handling these informations, because through the Vodafone company, telecom provider, all information is received by the, when ICICI gave any information, it was through the mobile phone and then to the person. So the Vodafone is the body corporate that actually handling, or you can say processing the information. Second is that it was a sensitive information. So to which information he was referring, because every 4 clause or 4 ingredients we have to observe of the section 43A. Here the argument of Sanjay Dande is that Vodafone has not provided a single information, rather the whole battery of the information, whole source they have provided to the accused or that person, and so that they got the information about my mobile banking. The third one is that whether they are negligent or not, and for that it was argued by the Sanjay Dande that they have to provide the SIM card with the proper verification, and without that they were the negligent. Okay, and section this explanation 2 that is attached to section 43 is talking about the agreement or some other law prescribe, etc. With respect to the telecommunication, there is the guideline that without proper verification SIM cannot be provided, etc. So they also defaulted that. To the wrongful gain or wrongful loss, yes, the Sanjay Dande has suffered the 90 lakh, and it was gained by the some unknown persons to him or to other persons who was not legally entitled to this money. Okay, ICICI Bank also, Sanjay Dande said that they are also responsible, because they are also having their sensitive personal data also, and they should have the 2-layer security or this type of the procedure. So they have failed. They provided the information. From these company, the argument was that they are not responsible because section 43 has not been attracted. So the main controversy is whether these two company, ICICI and Vodafone, are responsible or not. So that is issue. Argument one side I have told. To the other side, these company have argued that they are not responsible. Vodafone said that they have not provided any information. Yes, there is lack, but they have not provided the information. To ICICI, they said that we have not any default, any negligence in that. And so it was before the adjudicating officer. Here the case that provided in your case material, you have find that this adjudicating officer said in the page number 7. Page number 5 and para number 2 to 6 deleted, then para number 7. The analysis, my analysis of the document, what the AO saying, adjudicating officer is saying. I just take 5 minutes, just bear it, and then class will be over. Para number 7, the first clause, that both ICICI and Vodafone, two big names in the banking and the telecom sector respectively, have badly let their customer down and totally non-repentant about their laxity, burdening conveyance, which has resulted into the crime. Before passing any order in this case, I think the important to realize that net banking and mobile banking are increasingly being promoted by the banks, okay, and used by their customer to do the financial transaction, while the customer are expected to use their discretion to secure their net banking, mobile banking and password. The onus of securing the customer data is on the bank. So that's the first thing. Then it say in the second clause, the third clause, that the government has realized critical importance of the security of the data proposed with bank and telecommunication companies, and has enacted laws, issued various guidelines to ensure the minimum security of the customer data and the money. Section 43 and 43A of the Information Technology Act are step in this direction. Likewise, the KYC norm issued by the RBI and the guidelines issued by the for issuance of the SIM card by the TRAI and DOT, Department of Telecommunication, are also measures that go long way to the protecting the interest of the innocent citizen. And then in the fourth clause in this para 7, that first let me deal with laxity with ICICI. They have that ICICI has been treating with KYC norm, but in the clause B saying that ICICI does not given the police the CCTV footage of ATM in the person where the check or the cash was withdrawn. They use the foreign IP address that was not. So there are many laxity, there was many default on behalf of the the ICICI, some that's showing their nature towards the company, and some that is important for our fixing the liability under section 43 capital A. Then in the next on the this para number 8, the clause G, you can read that when a citizen apply for obtain the SIM card, he provide a battery of information which is personal and sensitive in nature. He repose his faith and trust in the company that his detail and data not be shared by third party. It is not hard to realize that such information, if falling in the wrong hand, can be misused. A SIM card is the variable key to the person's sensitive financial and personal information. Realizing there are clear guidelines by DOT regarding the issuance of the SIM card, and that has not been properly followed by the Vodafone company. Then you read on the page number 11, para number 8 also, and then even the adjudicating officer is saying that this Mr. Sanjay Dande was served as a director of Indian Institute of Technology for 11 years, has been awarded Padam Shri for his services to the nation, and presently the member of National Security Advisory Board. And these bank and the Vodafone company is showing so much laxity, so much boldness, so much they are not showing any interest. They have not provided any other information. So how they are dealing with their customer. It's really shocking fact that adjudicating officer is observing. And then the AO held that both ICICI and Vodafone are liable, but the ICICI is less liable. Vodafone is more liable because they have provided the duplicate SIM to those wrongdoer without any verification, and that would lead to all the informations in the hand of the wrongdoer. So out of 19 lakh 18 lakh compensation awarded, and 18 lakh was divided. 12 lakh to the Vodafone has to pay, 6 lakh ICICI has to pay. You can read in at para number page number 12 to this. And then the adjudicating officer is also having that there must be some security procedure in that. These big name companies should also have to follow all the guidelines strictly, so that there would not be any wrong in the future. So please go through this case of Sri Sanjay Dande, and with this today class is over. I have taken 5-6 minute extra, sorry for that. And